It's injunctive relief to get them to stop doing this and dominating this space. There are a series of fines and penalties and damages that the federal government can collect, fees and costs that the states can collect. So this is obviously a very big case on top of a number of other cases that we're investigating or bringing against Google.
It is a very big case. I mean, Google published a 3-page response in the past 24 hours and said that the DOJ's claims mischaracterize the business, and they say to support all these goals, we've invested in and built products to support this industry for well over a decade, that the lawsuit puts at risk billions of dollars of value for publishers and advertisers and useful ads and secure online experiences for consumers. How do you respond to their response?
Look, you have Democrats, Republicans coming together, state attorneys general. You got the DOJ coming together with us to bring this case. And we know they own the publisher side, all the technology around publishers and the websites that host advertising. They own the advertiser side, so all the technology that enables advertisers to get on these platforms and websites. And they own the exchange. They own AdX. I mean, the conflicts, again, are enormous. And the analogy is so apt. It's as if Goldman or Citibank owned the New York Stock Exchange.
I mean, by calling for this specific divestitures, you've got some antitrust experts suggesting that this is going even further and seeking a breakup than would have been anticipated. Is there a legal precedent? Have we seen something like this play out elsewhere before, especially where big tech is concerned?
You know, in the antitrust space, we say if there hadn't been an antitrust investigation and enforcement action against Microsoft more than 20 years ago, there wouldn't be a Google, and there wouldn't be a Facebook, and there wouldn't be an Amazon.
You know, it's easy to say it. It's harder to prove it, I guess. And I just wonder, when it comes to evidence and what you expect you're going to provide to sway the court, so to speak, to your side. I mean, for example, they say that your claims that publishers are required to use their ad server in order to access the ad exchange is untrue, and you have no evidence to back it up. So what do you see as evidence?
We have an enormous trove of evidence, and it's really Google's own documents. And so as this proceeds, we'll continue to talk more about what Google says about itself, about how it dominates this market, about how it shuts out competitors. It gets more than 30 cents per dollar of advertising dollar on the internet because of its dominance, because of its monopoly power, and the way that it uses that power to prejudice competitors and consumers.
How do you view, for example, we talk a lot about the growing, exploding, really, ad business at, say, an Amazon. Is that not a competitive threat?
It is a competitive threat, but what Google's doing is it's so dominant that even big companies like Facebook and Amazon and others also in this ad space are getting shortchanged and pushed out of the market because of Google's really global dominance in this space.
How long do you see this playing out over?
This will take some time. Obviously, it's a big case. This is on top of the in-app purchases case and investigation that we have, on top of the search cases that we have. So there's a lot of activity in this space, but I think of Connecticut businesses, right? Small businesses, big businesses that need to get on the internet because this is where all the action is to advertise, and how they get shut out and prejudiced and how they have to pay more to advertise because of Google's dominance.